has a different impact on a court as a piece of paper, which is words. So therefore it was important for the court yesterday to pause when it did and then retire to indeed consider sentence. Those were the aspects as stated, dealt with by the defense, and I will now deal with the aggravating circumstances as indicated or raised by Advocate Caesar on behalf of the state. The state submitted that they request that the court should consider a custodial sentence in this matter for the following reasons: that the incident was planned and it was deliberate and executed with precision, and that the submission is made based on the accused's own evidence. Also on this aspect, I would say we will deal with the merits once we reach that point. Further, that it was a collective decision made by the EFF's leadership, and that it was planned to entertain the crowd to ensure that the crowd is not bored during the event. In this regard, the state relies on the submissions based on the evidence of the accused that, I quote, everything was perfect and calculated and designed to be the way it was done, unquote. Therefore, it was not an act based on a lapse of judgment. These submissions was then substantiated based on the case law by the defense and similarly quoted then by the state. The state and the defense basically, in fact, relied on the same case law pertaining to this matter. The state continued to submit that on the ballistic evidence presented, it was established that to discharge a semi-automatic rifle in a built-up area densely populated using a .223 Remington round was fired, and that retains lethal kinetic energy on descent. The potential for mass injury or harm was real, it was foreseeable and scientifically established. Mtansane is a residential area. The state alluded to the fact that the accused position as a public leader and role model is, I would say, a fact. Submissions made thereafter by the state requested the court to consider that the accused is a member of parliament and also the president of a political party, admired and followed by millions of South African citizens, and arguing that it is aggravating and not mitigating as per the defense submissions in this regard. The state referred to the video footage which was accepted by court. That again, I will say, deals with the merits. It was clear what footage was admitted by court and what was not admitted. The state alleged that the accused clearly lacked insight and accountability and sought political justification as an excuse, thereby undermining the public confidence in the administration of justice. These submissions was followed by the concerns the state raised regarding the evidence and pre-sentence report drafted by Ms. Thompson and the findings by the witness and the submissions by the defense regarding the brevity of the possession and that it was not accidental, and that the discharge of a semi-automatic rifle cannot be described as benign, and since the risk of injury or harm is extreme. Celebratory purposes in this regard, the state submitted that this type may not be condoned, this type of discharge may not be condoned, and that the law makes no provision for such actions. The state then embarked on the discussion and submissions regarding the case law which was placed on record. I am not going to repeat, it has been noted. The only difference I may add by the side is that although the state and the defense relied on the same case law, it is clear that the state will use the portions which is beneficial to them, and the defense would obviously use the portions which is beneficial to the defense. And ultimately, at the end, the court is required to bring them together. The fact that the state further continued that the fact that there appears to be no harm or injury caused as a result of the commission of the offence is conceded by the state, however disagrees with the defence regarding the weight that it should be attached by court. The Parliament criminalised the creation of risk, not that there is a requirement of an actual harm or injury, but the actual act itself. The state continued to highlight three, which they termed, I'll say, pointers, that being the imperative of equality before the law. I'm not going to elaborate on that point at this stage. The imperative of proportionality and the imperative of deterrence. Those were the three highlighted by the state. And concluded its submissions by referring to State v. Zinn and pressing I'm trying to also expedite the sentence, just a minute. The state then submitted that the proposed sentences will give proper effect to all the principles and objectives set out in State v. Zinn with safety, and it will satisfy the constitutional mandate of equal treatment before the law, and it will serve the legitimate and pressing interests of a society, the right to expect its leaders to obey the same laws they are elected to uphold. Now, the court will proceed with the principles traditionally taken into account by sentencing court. It is a well-known fact that sentence proceedings are the most difficult part of any court proceedings. It does not only affect the accused person, but also the family of the offender, including the society, that being the public welfare, safety, concern, and the interest of society. It is also known that a court is obliged to consider the normal aspects of sentence traditionally taken into account before imposing sentence. These aspects being the accused is indeed a first offender before court and has no outstanding or pending criminal matters. It also includes the possibility of reoffending. I'm not going to elaborate on that aspect. It was done by the defense. It is noted as one of the principles to be taken into account. It also includes loss of employment. In this instance, the case law is clear that should sentence result in the loss of employment, it should be noted that crime is an inevitable consequence of crime, or loss of employment is an inevitable consequence of crime. The court is also obliged to consider the family of the offender. This fact was fully discussed in the pre-sentence report submitted by Ms. Thompson, who testified in mitigation of sentence. On this score, I also think it is appropriate to highlight, I do not intend to discuss the depth of the pre-sentence report, as was submitted by the defense in the heads yesterday, orally, that I accept it was an invasion of the accused's personal space. It could never be seen as an easy exercise. And we heard that evidence of Ms. Thompson, I think, in excess of 5 hours on the 23rd of January. And I think that in itself was surely not a pleasant experience. So I'm merely going to highlight how I have highlighted the content, and then the family, etc. I do not intend to rehash personal circumstances which has been dealt with or heard. The other aspect that the court needs to consider is the state of health of the offender, and the court was informed that the accused does not suffer of any medical or physical ailments as per the report. Youthfulness, it is so that the accused is still relatively young. And most importantly, the position of trust. This is one pointer that the court will return to. It requires full reasoning by court, and I will do so during the process of sentencing. The further aspect is that the prevalence and seriousness of the offence. This is an aspect the court cannot shy away from today, but also requires full reasoning, and the court will do so during the proceeding of the sentence. Those two aspects. The above are but a few pointers traditionally taken into account by courts before sentence, and some require a detailed explanation by courts. It is well known that the ends of justice are four in number, being deterring, preventative, reformative, and retributive in its nature. It, however, consists of five important functions. It should act as a general deterrent. It should also act as a specific deterrent. It should also, or it must enable the possibility of correction. And it must be protective of society. And it must further also serve society's desire that crime be adequately addressed by courts. It is in the public interest that punishment be meted out fairly and without the measure of excessiveness that would mark it as being merciless and unacceptably unfair. The court is mindful that neither the call for true punishment and revenge, neither the cry for understanding must be given undue weight. The ends of justice, as mentioned already, must be given due regard when determining sentence. And it is required that a court should strive to accomplish and arrive at a judicious counterbalance between the elements mentioned and ensure that one element is not unduly accentuated at the expense or exclusion of any other element. It has been often stated in various case law that the sentence imposed should fit the offender as well as the crime. It must